Hi again, Steve Vonner, litigation attorney. We are talking in this video about copyright infringement damages. There's a lot of confusion about copyright infringement damages. You have some people are getting letters for takedowns and infringement letters. Copyright bullies are saying you stole my photo, you stole my video, you stole my book, you infringer, you pirate. All kinds of things are going on, and people are asking what type of damages can you get in a federal copyright infringement lawsuit? And this video attempts to address that. So let's go without further ado to the Attorney Steve litigation whiteboard. All right, let's back it up here. Let's back it up. Okay, so we're going to talk about some of the different types of damages that are available in a federal copyright infringement action. Now, when I say federal, it's because copyright law is exclusive federal court jurisdiction, so these are the types of cases that will wind up in a federal court. So let's talk a little bit about the types of damages. I know there's a lot of information on the board. We're just going to go through and check it as we go, okay? One of the first, there's two types of damages that you can claim basically in a federal copyright case. One is your actual plus profits of the defendant, your actual damages plus your profits of the defendants. So let's call this A, okay? So where you can show your actual losses, your lost licensing fees, your lost support fees. Okay, this is a question that comes up. Can I get my maintenance and support fees that I would normally be getting if they would have paid for the copyright, if they'd have paid for the software? That depends. That's a tight issue. Okay, if your software is the kind that won't run without support, everybody buys support, all your records show that everybody that buys your software typically would end up also purchasing the support so they can get the upgrades and so it can work on all their computers, you may have a good argument to your support fees. And if somebody has been infringing your software for 2 years, 3 years, 4 years on 100 different computers, that could be a substantial damage award. So these would be considered your actual damages. Can you prove what your actual damages were? Okay, so this is what we talked about there, your profits. You may also be able to prove defendant's profits. What do we mean by that? Okay, so say one of the types of companies that will enforce vigorously their software rights is Autodesk. So say you have, and they have auto design software, so you have a small architect firm, 10 architects, and they're using your software, not paying for it, not using it, and everything else, and they have $1 million a year business. Well, you might be able to go prove, it's not easy, but with forensic accounting and things like that, you may be able to go prove that they made all this money because of your software, and you're going to have to, that's a proof issue, and you're going to have to go and prove that, how much money they made, and the defendant will have to show what their deductible expenses were that were unrelated to the copyright. So you may have a way to show defendant's profits. So you may elect remedy, what I'll call remedy A. They don't call it that, I call it that. But say remedy A, if you have significant actual and profits to the defendant, then you can show your damages. This is one way to get a damage award. If you're looking for the part on defendant's profits, I'm going to give you a case you can look up. Loratex, I'm going to give you the site, 519 F Federal Supplement 730. That talks about what you need to do to prove that up, and it's a case that talks about defendant's profits, okay? So we've talked about this, we've talked about this. We're already halfway through the board. If you're still with us, you're destined to be a star in the copyright world. And by the way, this all comes under 17 USC 504. This is your infringement damages under copyright law. Check. It's getting hairy around here. So you check that off right there. And so this may be remedy A, you may pursue that. The other remedy, which oftentimes comes in where you can't prove these kinds of damages, you can't get in a forensic accountant, it's going to be this major pain, is statutory damages. Okay, so we will call this B. You get one or the other, you can't get both. Some people say, well, can I get actuals and my statutory, or profits and my statutory? No. You choose one, okay? The copyright statute, 17 U.S.C. 504, only allows you to choose one of these remedies, okay? So statutory, what's that? Okay, this is where it gets a little confusing, okay, for the average person. Not for Attorney Steve, we got you. Your statutory damages are anywhere from $750 to $30,000. Let's check that off. $750 to $30,000. Well, how do you tell what's the difference? It depends on the seriousness of the act, and it could also depend on defendant's net worth. That may be another thing. But what's going to happen in these statutory infringement cases is the court's going to look at the facts. They're going to try to achieve a just and fair result, which is very fact specific. Okay, and they're going to basically look at this. Is this an innocent infringement? Is this unintentional? Is this something that just accidentally happened as the company was growing or moving its headquarters? Who knows? So these are things that are going to be looked at. The damages in this category can range from $750 to $30,000. Now, if the defendant, there is a statutory section also that often gets overlooked that says if a defendant can show it's completely innocent, there is a $200 statutory award. So it could be as low as $200 for an innocent infringement. Okay, so but that's the low end. Okay. Let's talk about over here. You get a right to a jury trial to fix the amount, ascertain the amount of damages. Again, very fact specific. The court's going to look when did they install this, when did they know, when did they copy, how much did they copy, how much did they pay. So all the factors are going to be weighed in a copyright case. The other part that everybody always talks about, you're a willful infringer, you're willful, you're going to jail, it's criminal copyright. These kinds of things. Is willful in a situation where you have a willful infringement. Again, looking at the facts, was it intentional? Did they have knowledge? Let's go over here. Did they have actual knowledge of the infringement? Did they have a reckless disregard as to whether or not they were infringing? These are the things that the court's going to look at in its analysis. Keep in mind there is a criminal component to the copyright laws where you willfully and criminally infringe things like movies. When you go to the movie theater, you always see that sign up there. If you willfully infringe, up to 5 years in prison, $250,000 in fines. I think we all know that. So it's a fine line between what is innocent, intentional, reckless, willful, but these are the types of inquiries that could happen in a criminal copyright case. If you have willful, if the plaintiff can show that, if the court agrees with that, if the jury agrees with that, the court may award up to $150,000. Now, people often ask me, $150,000 per infringement? No, it's $150,000 per work. So in other words, if you have one copyrighted book and somebody's infringing it 1,000 times, you get one infringement per work. So if you have 10 different software programs, each software program is individually licensed, now you have 10 works. So, for example, you may have 5 different Microsoft products. Each one has its own copyright registration. You have 5 infringing works, but a potential for, I don't know what that is, $750,000, something like that. So if they've proved willful infringement, the court may go up to $150,000. Okay. Again, damages should bear some relation to the damages suffered. There should be some logical relation. So some people will be like, well, somebody played my song in public and I want $150,000. Probably not going to happen. So, think about that before you do. Again, it's per work infringed. If you want the case on that, we have VMG Records 109 F Sup 2nd 1223. 109 F Sup 2nd 1223. Let's check that off. We have some factors the court will look at in making this determination on the willfulness, profits made, mindset of the defendant, the value of the copyright. The deterrent effect will also be weighed in, and defendant's conduct, whether it's intentional, willful. There's lots of different factors that the courts can look at. If you want a case on that, look at the Fitzgerald case, 887 Federal 2nd 1110. Okay. Last question, a couple other things that you can get in every copyright case. You can get an injunction to stop the offending use. You can get the court to order them to destroy it. You can get costs, prejudgment interest, and so forth and so on. Final question we get is statutory multiplier. Can you get a statutory multiplier times 2, times 3, times 4, times 5? There is case law on this. You'll have to print it up and look close, or go to our website at federalcopyrightlawyers.com to get the case citations. But there is some legal authority about getting multipliers. So if you need a copyright lawyer, Attorney Steve Vondran, we're licensed in California and Arizona. Give us a call. We look forward to working on your case and seeing what we can do for you. Thanks a lot now.